What to do when feeling pressured to sign a legal document? That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hey everyone, this is Mac Pierre Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
And I'm Fran Brockstein in Marble Falls, Texas. I'm an attorney and a mediator.
Yes, awesome. And Fran, welcome back. So let me share your site with folks so they can know how to get in touch with you. In case they do, familylaw4u.com, familylaw4u.com, and 4 is a number 4. Should be coming up on the screen any second now. If you're listening to this podcast, be sure to check out Fran at familylaw4u.com, 4 as the number. All right. So, Fran, topic today is what to do when feeling pressure to sign a legal document. And this has come up because you have mentioned that you are seeing multiple instances where people are mentioning to you that they're having difficulty feeling pressure to sign something that's going to have long-term legal consequences for them, whether it's a mediation agreement or maybe somebody's going to buy a car or home documents. Sometimes feeling pressure from a salesperson or from a spouse or maybe from a mediator because you're trying to make an agreement, but you don't feel comfortable with it. Why is this an important topic to you? Why did you suggest that we talk about it today?
Well, because if you sign, generally it's a legal agreement. And even with a notary, I'm a notary. And when I notarize documents for people, I ask them, are you signing this of your own free will and for the purposes and considerations therein expressed? And so you can't argue later that you were forced to sign a legal document. So I just had a lady call me about a medical power of attorney, and a relative of hers was trying to force her to sign a medical power of attorney. And she wasn't comfortable giving that individual those powers. And so I said to her, you need to pick someone that you trust, that you feel comfortable with. And if it's not this person, don't sign it. You're in control. The person could try to pressure you, but you are the boss, so to speak. And the same thing has come up numerous times at mediation, where I've had people call me the day after a mediation say, I was forced to sign the mediated settlement agreement and I don't want to follow it. I want to get out of it. I'm like, if you read all the fine print, it says that once you sign it, it's non-revocable. So I have had people in the past that are not comfortable signing an MSA. And I respect that. I tell them to go home and sleep on it, think about it. They need to pray on it, whatever they need to do. And we can execute it a day or two later. A mediated settlement agreement, especially in Texas, is so powerful that you should not sign if you're having second thoughts, because you can't revoke it.
Yeah.
So
So
I'm a real believer in going slow.
yeah, I think in the Texas Civil Practice Remedies Code, there's reference to the fine print you mentioned a second ago, which is that once you sign, it's binding and irrevocable. But it's actually not fine print. In fact, the law says it needs to be bold and conspicuous so that everyone is clear. And every mediation agreement that you ever review, if you're in mediation, you're going to see that language is thick, black, and bold, and it's going to say very, very thickly, hey, don't sign this thing because if you do, it is binding, irrevocable, you can't change your mind, and the other side has a right to a judgment on it. So this has big consequences. So yeah, most judges are not going to, have too much patience for people who come back and say, well, I didn't know that I couldn't change my mind. No, it says it on its face. You can't change your mind. However, there are, by the way, some exceptions, and we're not here to give legal advice, but you can talk to a lawyer about what those exceptions are, like violence and stuff like that. Um, but typically, you're stuck with it. So there's long-term consequences for something that you put your signature to. And I think this example that you've brought up in a mediation setting is a very good one, because one thing we have in mediation is called agency, and the other thing we have in mediation is self-determination. These are concepts that are ingrained in the conflict resolution process or dispute resolution process, where the party is, you know, supposed to understand that they are the master of their own destiny as to what happens in the final document they put their signature to. It's not the mediator. The mediator is not the judge here. They cannot force you to do anything. It's a voluntary process. And so the judge might make you go to mediation, but they can't make you agree to anything. You still have your right to day in court. And so it's very important that people remember this, that when they are signing the document, they are the ones in full power and control over what they sign to and whether or not they approve this. And so your number one tip, Fran, is to go slow.
Go
Right?
slow, and you hit the nail on the head. It's their agreement. It's not my agreement.
Correct.
I'm there to facilitate the event, but I'm not there to make the decisions. And it's also and I've had many people call me sometimes, and I've had attorneys, parties, and including myself, will forget to put something in the mediated settlement agreement.
Yeah.
And so it is very important that the person make sure everything they want is clearly spelled out. Many times people come back to me, and at the time of the mediation, the attorneys, the parties, and I all thought it was clear as glass.
Yep.
The week or two later, I read it and I go, that's as dirty as mud. I wasn't clear at the time. And no one brought it up.
Yeah.
So sometimes we've had to do a mini mediation section on, like one issue that just
correct.
wasn't clear. And guess what? That happens. You get tired. And even though I've been doing this 30 years, so I've made mistakes, and I readily admit it, and I will facilitate fixing it. But that's why I tell people, keep a running list and make sure everything you want is clearly spelled out in the mediated settlement agreement.
Yeah. Well, Fran, when you've done mediations for me, as whenever I'm representing one party, and by the way, you're a very good mediator. This is why we've gone to you, and because you're neutral, you're objective, and you're not in it for one side. You're in it to try to help the parties genuinely resolve their dispute. But when you've done it, I've noticed that your MSAs, your mediated settlement agreements, are written in plain English so that people cannot say that they didn't understand what they read and signed. And so that's a very important thing. But with regards to making a mistake on there, suppose people go to mediation with you or with me or somebody else, resolve the case so they believe, sign off on it, file it with the court, and then people come to the realization, one side or both sides, or even everybody involved, hey, that's not what we actually meant. This has a different impact that we thought. And then it goes to the court and you want to try to fix it. Note, another reason why it's important to be careful what you sign is that even fixing it can become a nightmare. A perfect example, where the parties have a mediation agreement. It's binding once they've all signed it, file it with the court, and the judge, and the parties change their mind. They want to take it away. The judge would not let us. The judge made us go back to mediation, have a new mediation agreement to undo the first one. That's how we could take care of it. Another example, parties agreed to one specific thing, in this case, to do a DNA testing outside of court. And this was agreed upon in the mediation agreement. Parties have a change of heart. They decide, you know what? Never mind. We don't need to do that part anymore. And we do what we call a Rule 11 agreement, where we try to amend the mediation agreement, file with the court, goes to court, try to get the case resolved. The judge sees that at the mediation agreement. She's like, nope, I'm not going to approve this. We had to go back to mediation to do another mediation agreement that says, okay, Everything in the prior mediation agreement is fine, except that we're not going to continue doing this portion about the genetic testing. So, lesson learned, just be very careful. Don't sign it, because trust me, the mediator is probably not going to have a problem taking your money again on a recess and doing it correctly the first time, and not make instead of making a mistake and having to correct it later on.
Well, Mac, we've worked together many times, so you know me. If there's a problem in the future, I've always offered mini mediations at a discount to fix anything. Um, and the people need to understand that attorneys do make mistakes. It's called the practice of law. It is an art. Nothing is ever 100% clear cut. And the Texas Supreme Court has come down on the trial judges repeatedly. They have to accept a mediated settlement agreement. There are very few ways they can wiggle out of it. So the trial judges have accepted the fact that they're going to stick to the mediated settlement agreements. But in the real world, in the life is not always, clean cut. There are boo-boos, and even the best attorneys sometimes have to fix things. And clients need to recognize that you do the best you can. But again, we're all human. We all make mistakes. And then my favorite, of course, is it's the same law in Texas, but every judge is different because they're human and they interpret the laws a bit different. So I have noticed since I moved up here to the Texas Hill Country, it is a little different than it was in practicing law in Houston. So I do warn people that each judge is a little different, and you need to write things up so that judge will be happy.
Yeah. So back to the question here, what to do when feeling pressured to sign a legal document. So your one tip, as in this series, Mediation Tips by Fran, this tip of slow down.
Sleep on it. I've actually taken a break and had everybody go for a 10-minute walk outside. I've had people go out and have a cigarette. I've had people call their mama or their best friend or whoever. And actually, sometimes the attorneys have stepped out. And we let the parties go in a room alone and talk about things between themselves. If they wanted me, I was there. So I always say a good mediator is creative. And so I do what the people want.
Well, Fran, one of the things that people listening might really think about is what is permissible. For example, you just said, call your mama if you want, sleep on it, walk away, come back. Well, what's permissible? Because we want people to know, not in every case can you have the opportunity to get feedback from some third person like your mother who's not your lawyer. If you are in a mediation closed setting where you're the only party, especially if you're pro se and you don't have a lawyer you can run things by, it's going to depend on the mediator, right? As to what is permissible. But the absolute one thing we can all agree on is nobody can make you sign. Like, that's the absolute.
Absolutely.
Yeah. And so might you get a chance to not sign, go home, sleep on it, and talk to your mom? Sure. Nobody can stop that. However, there might be a consequence from it, because once you leave the mediation and there's an impasse, there's a potential consequence that might happen because of the other side. And they get into some gray territory. But anyway, you are very flexible. You're creative. You give all these different options. But just so that people know, it might depend on the mediator in the other side as well.
And Mac, I absolutely agree with you. If you don't sign, the other side may change their mind.
Yeah.
And that has happened.
Yeah. You might have gotten a better deal if they did sign and you signed too, right? And so one thing we don't want regrets. That's the worst thing in life, is having regrets. But I've seen it too often. And I've had cases where my client regret the next day. And this is where I'm not a mediator, but I'm a partisan. I represent one of the parties. And I always tell my clients, every single client at mediation, listen, you do not have to sign this. we are signing this. You sign this by with my guidance because you believe this is the better outcome than what could possibly happen in court. Always frame it that way so the party is clear. But I've never pressured someone to sign because I don't want that in my conscience. I don't want somebody to say my lawyer made me. Nobody can make you sign anything voluntary. Nobody.
And I always say a mediation is really hard. And at the end of the day, if neither one of you are 100% happy and we resolve the case, that's usually a good mediation. As I tell people, I don't have a horse in this race. I'm an independent third party looking in at your life for a few minutes.
Yeah.
I tend, because I'm older and I'm on my third marriage, I give a lot of common sense advice. I don't give legal advice. But people need to realize that if they walk away, the other side may have regrets the next day. So every case, one reason I mediate is because I've never done the same case twice in my entire career. Similar, but never exactly the same because each person is a little different.
Yeah.
And I find it interesting. I never know what settles a case. I've actually settled a case over a mom getting the kid's turtle. She wanted one more thing, and she wasn't allowed to have the kid's cat or dog, but the kids had a turtle. So she got their turtle, so they had a pet to visit when they were with her. And so all these years, I've always laughed about the turtle case.
Good one.
Yeah.
So, yeah, I never know either where a case might settle when they're coming to me. And sometimes it takes an I'm sorry. Sometimes it's because someone just kind of grew tired and they want it to be over and they're willing to sign.
Yeah.
Especially if they're going to the thing for years and years. And the thought of another day of going through court is not worth the pain that might come if you just resolve it right now. You know?
And I just warn people that there's no such thing as a slam dunk in the courtroom. Yeah. There's, as one judge used to say many years ago on the bench, even the thinnest pancake has two sides. As I've gotten older, I actually believe that it's more like a square, that you maybe have four sides. But it is interesting that people need to realize that they're not going to get 100% in front of the judge. You never know what the judge is going to do. So a hard day at mediation is usually better than a day in court.
Exactly. So we could talk about this all day.
Yeah.
But bottom line is, what do you do when you're feeling pressure to sign a legal document? Don't. And get legal advice.
And feel free to mention your feelings to the mediator.
Yeah.
A mediator should listen to your fears and your concerns.
Yeah.
There are some mediators that are known for really pushing settlement. I'm not of the school of that particular mindset because I've seen people that regret it later.
Yeah, no, I've had a couple of instances where the mediator slammed the door on my client. And, both myself and my client are thinking that this is very unprofessional and rude. And obviously it was a pressure tactic, maybe to try to persuade the side to settle. But some people need to go to court.
Some people do.
If a case gets to that point where you're resorting to slamming doors, maybe.
And there are mediators that keep track of that they only keep track. They claim they settle 100% of their cases. I don't do that.
Correct.
That's not my philosophy. So, it is important to, before you even go to mediation, understand the mediator's philosophy.
Yeah.
Because we're human. We have different perspectives. My ego is not tied up in the settlement. And some mediators advertise, I have a 99.9% settlement, or I have a 100% settlement rate. I have a great settlement rate. I just don't advertise it because I refuse to force people to settle.
Got it. All right, Fran, our 20 minutes are up.
Okay.
And so we like to be very concise with time here. So thank you so much, everybody, for listening in. And check out Fran at familylawforyou.com if you want to use her services. Okay, until next time, take care.